recollection of what the evidence was. Your recollection of the evidence may differ from that of the attorneys, and in that event, you should rely upon your own recollection of the evidence. These arguments are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. State ready to proceed?
Yes, Your Honor.
Please do.
May it please the court, counsel. Good afternoon, everyone. I know it's been a long week. I appreciate your attention. The defendant in this case, as you know, has been charged with 3 different offenses, crimes. First one was aggravated manslaughter of a child. Second one was third-degree murder, not premeditated during a felony. And the third one was leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or as in this case, death. I want to go through these counts in a little bit of detail, and there are lesser included offenses as well, so I want to go through that. The state, in order to prove aggravated manslaughter of a child, has to show 3 things. One, that Araya Page, the victim in this case, the 10-month-old infant, is unfortunately deceased. She is dead. We have proven that. Number 2, the death of Araya Page was caused by the culpable negligence of the defendant, who is seated in the courtroom today. I want to tell you, the court's going to tell you later during the jury instructions what is culpable negligence. The judge is going to read to you a bunch of instructions, but I want to tell you just a small portion of it. Culpable negligence means that every person has a duty to act reasonably towards others. If there's a violation of that duty, without any conscious intention to harm, that violation is negligence. The important thing here is, if there's a violation of a duty to be a nanny, a duty to be a babysitter, even if you don't have a conscious intention to harm somebody, then it is culpable negligence. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm to the victim, in this case being Araya Page. And the state has proven that the defendant engaged in a course of conduct by leaving the baby in the car for a little bit over 5 hours. That is, it is reasonable to expect that the baby would die. Another thing I want to say about neglect. Neglect can be based on repeated conduct, meaning it happens many times, or on a single incident like this one, or omission by a caregiver. The defendant admitted on the stand she was a caregiver. Omission by a caregiver that results in or could reasonably be expected to result in serious physical injury, or in this case, death. That's what we have here. This is aggravated manslaughter of a child. The state has proven all 3 elements. But there are some lesser elements, offenses, I should say. And I'm going to go through these. The state feels that you should find the defendant guilty of aggravated manslaughter of a child. But the first lesser is manslaughter. This is the difference between manslaughter and aggravated manslaughter. Manslaughter, I need to show 2 things. One of them is Araya is dead. Obviously, we've proven that. Unfortunately, she is deceased. 2, the death of Araya was caused by the culpable negligence of the defendant. Once again, we prove that. That's all I need to prove. The difference, aggravated manslaughter has a third element that we proved, that Araya was a child at that time. She was only 10 months old. Brooke and Justice both took the stand. They told you what her date of birth was. They told you she was 10 months old in July of 2023. Paul Dickinson, the EMS paramedic, took the stand and said he determined she was 10 months old. Dr. Aaron Ward took the stand. He said she was 10 months old. Dr. Thomas Coyne, the medical examiner, said he determined she was 10 months old. The state has proven she's a child. So there's no doubt of that. Also, for this to be aggravated manslaughter of a child, the state has to show a caregiver. That's the key word, a caregiver, that the defendant was a caregiver for Araya, and we have shown that. So the state is saying to find her guilty of aggravated manslaughter of a child. We have met all three elements. The regular manslaughter doesn't really involve a child. Then we go to another lesser included offense that you have a choice of. Once again, the state is not asking you to find her guilty of this one. We want you to find her guilty of aggravated manslaughter of a child. The next one is called neglect of a child with great bodily harm, permanent disability, or permanent disability. This is what I would need to show. Number one, the defendant, by culpable negligence, failed or omitted to provide Araya with care, supervision, and services necessary to maintain her physical or mental health. Two, that the defendant caused great bodily harm to Araya. Three, she was a caregiver. Four, that Araya was under the age of 18. Well, there's one thing missing here. I don't need to prove that Araya is deceased or that she's dead in this one. That's why the state is saying, no, we want aggravated manslaughter of a child. Araya is dead. That's the proper one to find her guilty of. But there's still 2 or 3 more lesser offenses that you can choose from. Another one is called neglect of a child without great bodily harm. That one, we have to show once again that the defendant, by culpable negligence, failed or omitted to provide Araya with care and supervision, that the defendant was a caregiver, and that Araya was under the age of 18. This one, once again, says without great bodily harm. No, Araya is dead. We go back to the aggravated manslaughter of a child. That is the proper one to find the defendant guilty of. Then we have 2 more left. Culpable negligence inflicting injury. I would have to prove 2 things here. The defendant inflicted actual personal injury on Araya, and she did through, once again, culpable negligence. In this one, the state would not even have to prove that Araya is a child. Obviously, we prove she's a child. We go back to the aggravated manslaughter of a child. That's what we want you to find her guilty of. And the very last one is just culpable negligence exposing a child to injury. No, Araya wasn't just exposed. Araya died because of this. So in the end, with aggravated manslaughter of a child, and you'll see on the verdict form that there are all these lessers, the state is asking you to find her guilty of the very first one, aggravated manslaughter of a child. Now there's 2 more counts that I want to go through, but I want to do it a little bit backwards. Rather than doing count 2 and then count 3, I'm going to go to count 3, and I'll explain why in a second. Count 3 is leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or in this case, death. This is what the state needs to prove. The defendant was a person responsible for Araya. State has proven that. Araya was under the age of 6 years old. Once again, the state proved that she was 10 months old. The defendant left Araya unattended or unsupervised in a motor vehicle for a period of in excess of 15 minutes. Think about this for a minute. All the state needs to show you is she left her in the vehicle for over 15 minutes. This defendant left Araya in the vehicle 20 times more than that. 15 minutes is all I need to prove. She left her for a little over 5 hours. And lastly, what I need to show is that in so doing, Rhonda Jewell, the defendant, caused great bodily harm, permanent disability, or permanent disfigurement to the child, Araya. Obviously, she did, because Araya is deceased because of this. We are asking you to find her guilty, the defendant, of leaving the child unattended or unsupervised in a motor vehicle which resulted in great bodily harm, as in this case, Araya is deceased. There's only one lesser, and basically what that one says is that the defendant left Araya in a vehicle, that the child was under the age of 6, it was over 15 minutes, but there's no injury. That is not one that you would check off. It would have to be leaving a child unsupervised, resulting in great bodily harm or death. Now I want to go to count 2. Count 2 and 3 are linked in that the crimes charged in count 3, which I just mentioned to you, leaving a child unattended in a motor vehicle, is an element of count 2. Count 2 is the third-degree murder charge. This is what the state needs to prove for count 2, third-degree murder, third-degree felony murder. It's unpremeditated. We're not saying that any of this is premeditated. We're saying this is not premeditated. Number 1, Araya is dead. We've proven that. Number 2, and this is the important part where count 3 comes into it. While engaged in the commission of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury, the defendant caused the death of Araya. You remember the example I gave, I think it was on Monday. I talked about if someone committed a felony, if someone robbed a bank, they had no intention of hurting someone. They wanted to rob the bank, and during the course of that robbery, unfortunately, somebody died. It's felony murder. What we're saying is the defendant in this case committed the felony of leaving a child unattended in a motor vehicle, unsupervised, and during the course of that crime, Araya died. That's what makes this a third-degree felony murder, and I stress to you, we're saying not premeditated. And the last element I need to show is that the defendant was a person who actually killed Araya, and she was. No one left Araya in the vehicle but the defendant. She's the one who did it. It wasn't like someone else came along and put the child in a car without her knowing. She drove to Stacy's house. She got there. She left her in the car. There's one lesser for that. It's, once again, it goes back to the manslaughter charge, just simple manslaughter. We are not asking for that in this one. We're asking for third-degree felony murder because in this one she was engaged in the commission of leaving a child unattended or unsupervised in a vehicle, and it resulted in Araya's death. You've all heard in the past 4 or 5 days what happened in this case. But there's some things I want to stress. The defendant in this case failed in her duty as a babysitter, as a nanny. You saw her take the stand yesterday. She actually admitted. These are things, and something that the court had just instructed you on. This is what I'm going through is my memory. Go with your memory. I know some of you have been taking notes. Go with your memory. But this is what I have. She admitted on the stand more than once that she failed in her duty of care. I asked her point blank, wouldn't you agree you failed in your duty of care? And she said yes. She admits it was her responsibility to care for Araya. She admitted on that day, for those 5 hours, she didn't do that. She admits that Araya died under her watch. She admits it was her job to watch Araya. She admits it was her responsibility to care for Araya on that day. She also admitted it was her fault Araya was dead. These are things I asked her. And like I said, go with your memory. But these are things she admitted on the stand. These are also things she admitted she didn't do on July 19th. She didn't feed Araya for those 5 hours. She didn't make baby bottles or baby foods, never changed her diaper, never put baby lotion on her, anything you would do for a baby. She didn't do any of that because Araya was in the car for 5 hours. Keep in mind that the defendant in this case is a paid babysitter or nanny. This is her job. Brooke and Justice entrusted her to take care of Araya for those 2 days, every week, whatever it was. They paid her to do this, and she made the decision and said, yes, I'll do this. She did not do this on this day at all. And don't just take my word on it, take her word. She said it yesterday on the stand. She did not do this for those 5 hours. Now let's talk about things she did remember. She remembered picking up Araya that day. She remembered that Brooke put her in the car. She remembered Brooke putting the baby bag in the car. She remembered going to the Burger King, or to the red light in front of the Burger King. She remembered going to Stacy's house. She remembered she got a can of chicken, bag of chips, her cell phone, her drink. She remembered that she texted Brooke twice. She Snapchatted with Nevaeh also. But she doesn't remember Araya. But she remembers everything else, but not Araya. The evidence that you heard and what the state has proven is that the defendant went to Brooke's house, Brooke and Justice's house, a little bit before 8. Her job was to get Araya. That's why she got up that morning, was to watch her and the other kids at Stacy's house. She drives to Brooke's house. Brooke puts Araya in the car with the baby bag, and the defendant then leaves. And Stacy's house is like 10 minutes, 15 minutes down the road. It isn't that far. But when she was asked yesterday on the stand by me, did you forget Araya when you were at the Burger King or the light in front of the Burger King? Her response was yes. We're talking about 5, 6 minutes. You get up in the morning, you drive to someone's house to pick up their child, and in 4 or 5 minutes you forgot all that? You forgot you got a baby in the back of the car? That doesn't make sense. Then she gets to Stacy's house, she gets out of the vehicle, Araya's still in the vehicle, but she goes in with everything else in her hand, the cell phone, the chips, and the chicken, and all that. But Araya's still in there, in the car. What was also interesting was when she's inside of the house at 8:17, and you can take this into evidence, the text message, you've all seen it. At 8:17, she texts Brooke to let her know that Stacy has left. And I asked her yesterday when she was on the stand, didn't that ring a bell? You're talking to Araya's mom. And she said, no, we talk all the time. And I even said to her something to the effect of, but you're texting her at 8:17 in the morning to let her know Stacy has left. Why else would you be doing that unless you had Araya with you? Then you text her another communication at 8:32 in the morning. Still, nothing went off in her head. Araya's in the car. She says, I forgot. It doesn't make sense. Then at 11:25, she talks to Nevaeh Carter. That's Araya's aunt, the young girl that took the stand yesterday. And she's that Snapchat photo responding to it. The point is she's having communication with her. Nothing goes off. But this is something else that's strange. When Brooke comes to pick up Araya, she knocks on the door, and we know this, there's no answer. She rings the doorbell, there's no answer. She then calls the defendant. And think of it. At that moment, when she calls the defendant, and the defendant says to her, "What door are you at?" And she says, "The front door." She's talking to Araya's mom. She's talking to her on the phone, hears her voice. It still doesn't go off that Araya's in the car. This doesn't make sense. And it is only when the door is opened and Brooke walks in, at that moment, the defendant starts screaming, "Brooke, Brooke," and runs out. So it didn't go off at 8:17 when she sent a text, 8:32 when she had another text, 11:25 when she talks to Brooke on the phone at around 1 o'clock or 1:15. None of that. It doesn't make sense. We all know what happened after that, unfortunately. EMS is called, Brooke calls 911, they arrive, the sheriff's office arrives, the fire chief arrives. Paul Dickinson took the stand, and he told you they were desperately trying to do CPR. Brooke had called her mother-in-law, Pamela Page, because she's a nurse for over 30 years, desperate to try to do something to save Araya. She said that I think the word she used was she felt, I think she said wet and rubbery. Her lips were blue. She's trying to desperately do CPR. Her mother-in-law is telling her, "This is what you need to do." Paul Dickinson comes in with his paramedic with him, and they both take over trying to do something. But he even said on the stand he realized that Araya was dead already. They noticed that the muscles had stiffened, rigor mortis had set in. The child was already deceased. And they then transferred the child to the hospital. Dr. Aaron Ward took the stand. He confirmed, obviously, that Araya, unfortunately, was deceased. After he got off the stand, the nurse took the stand, Charles Smith. And Charles Smith said that the temperature was taken of the child. And at that point, and keep in mind, Araya has been taken out of the car, put in a garage so they can try to do CPR, put in an ambulance, which I assume was probably air-conditioned, but put in an ambulance, taken to the emergency room, and I'm sure the emergency room is air-conditioned. So some time has passed, but her temperature at that point is 110 degrees. And Nurse Smith said he doesn't remember if the thermometer went over 110. Maybe it did, maybe it didn't, but it was 110 at that point, meaning it could have been higher. And then Dr. Thomas Coyne, the medical examiner, took the stand. And really, what we learned from that was he said the cause of death was hyperthermia, overheat of the body. But he also said that when he did the internal exam and the external exam of Araya, she appeared to him to be a perfectly normal child. He could find nothing except that she had been left in a car for 5 hours. He described what happens when someone is in that situation or an infant is in that situation. He described what happens to a person or infant's body, their organs, their brain swells, what someone would be going through in that situation. The defendant, as you know, was interviewed by investigator Brad Dougherty. I'd like to show you a clip of that if we could.
Sir, you wait out home. Yes, no problem, sir. You can have a seat I'm second guard is to take the courage. I know this is very difficult, okay, you just gotta get through it, get a statement from me. But because you are here at the sheriff's office, and we're here talking to you in here, I gotta still let you know what your rights are, okay? Doesn't mean that you're arrested, just means you gotta know what your rights are, because we're talking to you in a place you may not feel free to leave, okay? So to take the courage, I'll read those to you.
All right, Ms. Rhonda, you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him or her present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning, if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand these rights as I've explained them to you? Okay, with these rights in mind, are you willing to answer some questions for us?
I know this is tough, I know it's very tough. Just kind of walk me through the day of what happened.
I picked her up about 8 o'clock. I usually keep her 2 days a week. So I work Monday at my other job, but some things that fell through, her husband only won't work night shift, so I went just Wednesday and Thursday at this place where I was at today.
The house where you was at today?
Okay. They have twins and a girl that I keep. Anyway, so on the same days, I pick up Araya from her house, but today was an earlier day because the other lady needed me at 8:15, so I picked her up at 8 o'clock, which is usually 8:30. Anyway, so I picked her up, and I pulled through Burger King to get something to eat, but the line was too long, so I left and went to the job I was at.
On a state street, correct? Right.
So I got there at 8:15, and the baby was like, because she was asleep and she was quiet, and because I don't keep her every day, I forgot she was there. So I went inside, got busy with the other kids, and I even talked to the mom throughout the day, and it just didn't click.
Right.
That the baby was outside.
So that was at 8 o'clock. What time did you realize the baby was outside?
When it was girl,
You know what time roughly that was?
1.
When 911 was called? Okay. How many kids were in the car when you got home with her, when you got to that house today? Just her?
Just her.
Just her? And the other kids were there, I'm assuming you babysit them for the family that lives at that house? Is that what they were already there? The homeowner that lives there, what's her name, do you know?
Stacy.
Stacy. Did Stacy know that you was bringing the other child?
No, because sometimes I have her and sometimes I don't.
Okay, so she had no idea. And where did you park at the driveway?
In the rocks.
In the rocks?
Pulled off into the rocks.
Okay. And the only reason I'm asking, I didn't know if maybe they would have seen anything when they left, when they left there. The stuff that's in the car, the baby stuff, is that for that child?
Yes, sir.
Okay. How long have you babysitted this child? How many?
Since probably, June.
Since June of this year? Do you do it every week or every day, or how does that work?
I was keeping her Mondays, with my other job, Monday, Wednesdays, and Thursdays. But she come to me a couple of weeks ago, about a month ago, and said, hey, my mother-in-law's gonna keep her on, Thursdays, so we'll just have her Mondays and Wednesdays.
Okay.
And so, because I didn't have this other job on Mondays because of their work schedule, I kept her on Monday, so I went and got her on Monday, and I've done all my errands in McClenny, and
Sorry.
I keep her till 1, till her mom comes and gets her. So I've done all my errands in McClenny, and her mom come and got her
Right.
at 1 o'clock. That was on Monday. and on Tuesdays I have off. And on Wednesday I went to my other job, and I usually take her with me, but that was on Wednesdays. On Thursdays I didn't have her anymore. On Thursdays her mother-in-law kept her.
So you said, just to go back and reiterate, you said when you got there to the house on the State Street that she was sound asleep. Was the plan to come out and get her a little bit, or?
No, I normally just get out and get her and take her inside.
But I'm saying, you said you noticed that she was asleep when you got there.
Well, I assumed she was asleep. She didn't want to make any noise.
Okay, she wasn't making any noise.
Yeah, I just picked her up. Her mom said that she would probably go to sleep, so I just assumed she had fell asleep, but she didn't make any noise.
This is what's interesting, and Investigator Dougherty questioned her on it further. And you can listen to that again if you need to. When you're in the jury room, you can come out, we can play it for you again and again. But she mentions to Investigator Dougherty that she got there, I think she says at 8:15, and she says something, the baby was, and then it's inaudible. I can't hear what she's saying. It's hard to make out, but she says the baby was something because she was asleep. She was quiet, and because I don't keep her every day. And then she says, I forgot she was there. And I go inside, I get busy with the other kids. Then she says, I even talked to the mom for a bit. It didn't click that the baby was outside. The investigator, Dougherty, then says to her later, like 3 minutes later, he says, you said you noticed she was asleep? And her response is, I assumed she was asleep. She wasn't making any noise. The mom told me she would probably go to sleep, and she wasn't making any noise. It's like two different stories. There's an inconsistency there. According to the defendant, if you believe what she said yesterday, she forgot Araya was in the vehicle by the time she got to the light where Burger King is. But my memory is when she was then questioned after I questioned her by defense counsel, it was, I don't remember if it was there or when I got to Stacy's. So in a matter of a minute or two, the story somewhat changed again yesterday when she was on the stand. You've seen this video. Keep in mind that this video, this interview of this defendant was done, I believe, at you can look at the time, I think it's at 2:42 on July 19th, or 2:41. Brooke has testified that she got to the house about 1:15. So it's roughly, I'll say, about an hour and a half later, she's being interviewed. About an hour and a half after realizing Araya is now dead. You can judge her demeanor on that video, how she appears to you. And I ask you to take that into account. You can judge her demeanor yesterday on the stand, how she appeared to you. And I ask you to take that into account. The body cam footage that we saw yesterday. You can watch that if you want to watch it. You can ask the court. You'd have to come out here. We would play it for you as well. This defendant cared for many things that day. Her phone, her trip to England, her kid is going to college, her lunch, her cell phone, but she didn't care for Araya on that day. She didn't watch Araya and make sure Araya was safe. She failed in that duty. Today, we heard from Dr. Brian Cahill. That was the expert that the defense put on the stand. I have a few things I want to say about Dr. Cahill. He talked about this thing called prospective memory error, forgetting to do something. In this case, it would be forgetting that Araya is in the car. When the court reads to you the jury instructions, you will never see the words prospective memory error. It's not in there. You will never see the words, "I forgot." It is not in there. It's not part of the jury instructions. A reasonable person might forget to lock the door when they leave the house. They might go back and check on it and realize, okay, I didn't lock the door. That isn't what we're talking about here. We're talking about a babysitter that left a 10-month-old in a car for over 5 hours. That's what we're talking about here. Dr. Cahill mentioned something. He said 25 is a number he threw out. 25% of parents forget their kids are in the car. That was the number he threw out. He didn't mention, at least from what I heard, unless you heard something different, do these parents, did they forget their child was in a car for a minute and then remember the child was in the car? Did they forget their child was in a car while they were listening to a song and 3 minutes later they realized the child's in the car? Did they forget their child was in the car for 2 hours, for 3 hours, for 5 hours? He didn't say. Is it just a moment? Is it hours? He didn't elaborate on that. But in this case, once again, we're talking about a babysitter who's being paid. She took the responsibility to care for this child, and she failed, and she admitted that on the stand. Dr. Cahill also talked about being rushed in a routine, that it can affect your memory. This isn't an excuse. Every person has some sort of a routine, and every person probably every day, something comes up you're not expecting, and you're rushed to do it. That doesn't excuse this kind of behavior. He mentioned something called retrieval cue. Something, I guess, to remind you. However, he said the text messages aren't a retrieval cue because they don't mention Araya in there, even though she's having contact with Brooke, the mother. The Snapchat, he said, isn't a retrieval cue because Araya's not mentioned in it. But a phone call from Brooke at 1 o'clock, the actual mother calls her, that's not going to be a retrieval cue? I don't know what would be if that isn't going to be one. To the state, the other ones are too. This isn't anyone's fault but the defendant's fault. It isn't Stacy Pascal's fault. The baby was asleep. Obviously, it's not the baby's fault. The baby's sleeping. She had the responsibility to care for this child. She failed in her duty. Just because you forget to do something doesn't mean that you can't and shouldn't be held responsible for it, that you shouldn't be accountable for it. I've given you this example on Monday. And I said, what if you have someone who is driving on the roads? They have a duty of care to be careful for themselves, but also for people who are driving around them. That's their duty when you get behind a wheel. If they're texting and they cause an accident and somebody dies, there's no intent that they wanted that to happen. They can't just say, I'm sorry, I didn't mean for this to happen. They're going to be held responsible and accountable. Something horrific happened. Like in this case, she says, I forgot. She has to be held accountable. She has to be held responsible. Araya is dead. Araya is dead forever. She's not coming back because she didn't do her duties that she said she would do. Another thing I mentioned on Monday, I mentioned about, I always call it the school bus puzzle. If some of the pieces of the school bus puzzle weren't in place, would you be able to say it's a school bus? Everyone, I think, said yes, they would, if it was missing a few pieces. This puzzle's a bit unique in that the state feels none of the pieces are missing. I could go through all the evidence that I've mentioned so far, but I'm not going to. But it's the text messages, what happened that day, the doctors, the witnesses, all of that. They're all pieces of a puzzle. But the biggest piece of the puzzle is she took the stand. She actually admitted that she failed in her duty, which makes her guilty of all the offenses. I mentioned to you, the judge is going to read you the jury instructions shortly. There's just a couple that I want to point out that I think, well, they're all important, but a couple I'd like to mention. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and the instructions that the judge will read to you. This case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Look, when you are part of a trial, it is easy to have your emotions affected. We're all human, that can happen. But you were all entrusted as jurors to follow the law. You can't let your emotions decide your verdict. You must decide this case on what the law says and what the facts are. Not how you feel about someone, whether you like someone or hate someone or feel sorry for someone. That isn't what we're here for. And the facts show that she failed in her duties and Ariah's dead because of her. That's what the facts are. And if you follow the law, you would find her guilty on all 3 counts. I will talk to you again after the defense does their closing. But I'll just end it for now with this. The state has proven this case beyond a reasonable doubt. We're asking you to find the defendant guilty of aggravated manslaughter of a child, Ariah. We're asking you to find the defendant guilty of leaving a child in a vehicle unintended for over 15 minutes because she left her for over 5 hours. And because of finding her guilty of that count, the 3rd count, you have to find her guilty of count 2. Because if someone leaves a child in a vehicle for over 15 minutes and they're dead, count 2, the felony murder, says if you commit a felony and somebody dies, then you're guilty of 3rd-degree felony murder. So the state feels we have proven all 3 counts, and we ask you to find her guilty on all 3 counts. Thank you for your time.
Defense?
Thank you, Your Honor. May it please the court,